Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about the dangers of co-founders with intellectual property and commercializing an idea with co-founders. I think one of the major misgivings in a lot of startup companies, they start a new company and it's usually two people working cooperatively and they decide to split the company 50-50. Sounds reasonable. The problem is that when you split the company 50-50, no one's actually driving the company anymore. Everything's a joint decision. Everything is basically democratically put to a vote. Now, the problem is that sometimes this doesn't work for a company. And companies, sometimes, particularly with co-founders, they might see eye to eye originally at the outset, but quite often 12 months later, their motivations for being in the company have changed, or their needs in the company have changed, or even things like their health might have deteriorated. Any raft of things might have happened to them. And they might not be seeing eye to eye as to how to drive the company forward. If the company is split 50-50, it means that the company will not be able to make decisions, will not be able to make payments, will not be able to make sales, will just not function at all. So really, if you are going into a 50-50 co-founder agreement, it's worthwhile having a discussion between you and your business partner to work out who's going to have the actual final say if there's a deadlock, or how you're going to break those deadlocks if something doesn't go right, or how you're going to break the company up if things don't work out in 12 months' time. What are you going to actually do? And this is particularly relevant if your co-founders are family members or close personal friends, particularly if you've got a relationship with these people outside of just your business environment. You've got to consider, well, what happens if this business goes badly? What happens if this business explodes? We can't operate in a year. What happens if this person gets so sick they can't work? And this regularly happens with new tech companies and co-founders. We don't know what's around the corner. We're not fortune tellers after all. When it comes to the law, what you should be thinking of is you should be thinking of a shareholder agreement. So when you start up a company, you should be thinking, how do I preserve the ability of the company to function if something goes wrong? A shareholder agreement does that to a limited extent. Lawyers go through this with both of the parties, so both the co-founders, and talk about both the risks of what goes on in the company. What happens if one of the business partners falls sick? What happens if you bring on a new investor? And these are all things you've got to consider. The other thing is you've got to consider, well, where is the money coming from to bankroll the company in the future? And particularly if it's a family member or a related party, like a husband or a wife, then you've got to really think about, well, what's the impact on that person investing in the company, particularly if they're only investing in it unilaterally, meaning that the other co-founder doesn't have the money to put into the company. All these things are really important things that you need to iron out at the very onset. And the earlier you get these things sorted out, and the earlier you put them into a shareholder agreement, the better it is for your startup company. I hope this has been really helpful, and if you need any information about shareholder agreements or how to manage equity for startup companies, particularly where it's got two co-founders, please feel free to contact myself or my team at Alder IP. We're more than happy to help you. And thanks for listening.